implication of treating a legal matter with levity. And that lawyer went as far as going to dish out misinformation to the Nigerian public using a very popular television station and a newspaper. Good enough, the television station would do the bulletin after they were confronted. But it had gone out, creating so much damage for the party and for our candidates. And so the Labour Party decided to petition to the Legal Practitioner Disciplinary Committee against that very lawyer. That is the essence of how we're here today, to read our letter that we did against that very lawyer. And so this is the text of the letter. Complaint against Monday Mawa. Gross professional misconduct, violative of Part 4 and 5 of the Rules of Professional Conduct 2023, amounting in law to infamous conduct and conduct unbecoming of a legal practitioner. Statement of fact. Sir, it is indeed with great trepidation that we write, given that this is a season of politicking and political turmoil, where even otherwise profoundly discreet, prudent, and circumspect people nurse no compunction or reservation about casting their peers before the swine. We are in a democracy, and stringent opposition to our party's candidates' emergence is expected. We have not been left disappointed, even if we have been a little surprised by the nature and provenance of these attacks. We are, however, surprised and taken aback that a member of the revered legal profession has thrown caution to the winds and has embarked on a voyage to spread false news, to bring both the bar and the bench to program. Delivering his judgment on the 24th August 2023, while the Court of Appeal sitting in Abuja was delivering its judgment, in appeal numbers CA/OW/CS/200/2023, and another appeal CA/OW/CX/201/2023, to wit, Sir Bassey Maduka versus LabourParty and two others, and LabourParty versus Bassey Maduka and two others, respectively. One Mr. Monday Mawa, a legal practitioner of Templum Solicitors of 84 Obafemi Awolowo Avenue, Abeokuta, Ogun State, with Abuja address as Suite 87, 3rd floor, Trinity House, Mabushi, Abuja, who is not a counsel in the matter and was not in court when the judgments were delivered, went on air on Channels Television and falsely, maliciously, and with intent to deceive, confirmed to the whole world that the decision of the Court of Appeal in the two appeals was the purported Lamidi Apapa-led faction of the Labour Party was declared as the authentic leadership of the Labour Party, and that the court had ordered that the names of candidates that emerged as winners in a purported primary election conducted by Lamidi, Apapa faction, be forwarded to INEC to be imputed as the candidates of Labour Party for the 2023 gubernatorial elections fixed for later in the year. The said Mr. Monday Mawa I should go on.
Go on.
Let me go back a little bit. Okay, that they said Monday Mawa, who is not a counsel in the matter and was not in court when the judgments were delivered, went on air on Channels Television and falsely, maliciously, with intent to deceive, confirmed to the whole wide world that the decision of the Court of Appeal in the two appeals was that the purported Lamidi Apapa-led group of the Labour Party was declared as the authentic leadership of the Labour Party, and that the court had ordered that the names of the candidates that emerged as winners in the purported primary election conducted by Lamidi Apapa faction be forwarded to INEC to be imputed as the candidates of the Labour Party for the 2023 gubernatorial elections fixed for later in the year. The said Mr. Monday Mawa falsely stated in an interview that the Court of Appeal had upheld the decision of the trial court, which the court never did. We put here the link where you can get that interview, the channel interview. I will give it to you after this statement. This utter falsehood, as openly stated on live television by the said Mr. Monday Mawa, was contrary to the decisions of the Honorable Court in its judgments in the appeals. In the Basil Maduka's appeal, the Court of Appeal sitting in Abuja dismissed the appeals simpliciter and held that the appellant had no local standing to institute the proceedings. In the Labour Party's appeal, the court held that the appeal was not necessary as the decision of the trial court was in its favor and that the mere comment of the trial judge in his judgment did not consist an appealable decision and should be discountenanced. In none of the two appeals, the Honorable Court proclaimed the orders that the said Mr. Monday Mawa had gone to town with and had impetuously proclaimed on live television to the whole world. So it is quite unbecoming that a lawyer of Monday Mawa's apparent ripe years at the bar should be allowed to continue to practice as a legal practitioner in Nigeria after putting out such riotous lies, which has now had the far-reaching ripples effect of painting the judiciary as a confused institution. By this conduct, Mr. Monday Mawa contravened Part 4 and 5 of the Rules of Professional Conduct, which deals with a lawyer's relations with the court and improper attraction of business. Our prayer goes as thus. We call on the committee to immediately commence the process of disciplining Mr. Monday Mawa for infamous conduct, infringing on the provisions of the Rules of Professional Conduct, to wit, Part 5, Relations with Court, and Part 4, Improper Attraction of Business, especially Rules 31, duty of lawyer to court and conduct in the court. Rule 32, candid and fair dealing. Rule 33, trial publicity. Rule 39, advertising and soliciting. And Rule 47, instigating controversy and litigation. Lawyers like Mr. Mondemawa pose a grave threat to the bar and the bench in a society of impressionable and gullible laymen like Nigeria. He should be disciplined, lest innocent Nigerians begin to take his words with more than a pinch of salt. Thank you so much. But let me also say, because here I have the CTC of the judgment of the appeal court, the two judgments that were delivered that very day. If you look at this judgment, it is Sir Basil Maduka, the appellant, and LabourParty 1, respondent, Independent National Electoral Commission 2, and Chief Ukebu Ikechukwu Joseph 3. You will not in any way see where they mentioned the name of Julius Abure. You will not see in any way where they mentioned the name of our candidate in Imo State. The court merely dealt on substantive motion brought before it. But because the said appellant, Mr. Basil Maduka, was aggrieved that the primaries that produced Chief Ukebu was false. And he was asking the court, both the lower court and the appeal court, to stop the recognition of Mr. Ukebu. The Labour Party led by Julius Abure was not put on notice. The Labour Party that Apapa claimed to lead was one who went to the court, and they represented themselves there. And we also find out that these two men are working together. Both the Ukebu and Maduka, they are working together. They are working for Apapa. So they are going to create the impression that Labour Party has been asked to recognize the winner of the election, and therefore that the name should be sent to INEC. But that is far from what transpired in the court. If you read a section of the judgment, it says, however, it will be improper for the court to make any pronouncement on the leadership dispute, of the first respondent, in this case, Labour Party, in this pronouncement of the leadership with the first respondent, in this appeal, as nothing in the notice of appeal here justifies it. It is improper for a court to go beyond the dispute submitted before it. So the dispute was very clear between the appellant and the respondent. Who won their primaries? The concocted primaries, the fake primaries conducted by unknown members of the party. Because they are not recognized by Labour Party. They have since been expelled from the party, some on suspension. But suddenly they came together and claimed that they are the authentic leaders of Labour Party. Simply because a court in Abuja here gave a substantive order, a restraining order to Julius Abure and 3 others. But we have gone ahead to appeal it. The appeal court said that the lower court should stay execution of whatever thing until they decide the outcome of the appeal. The appeal is still there, has not been decided. And based on that, you appointed yourself the deputy, the acting national chairman of the party. In this party, we have 3 deputies. So, and in the constitution of the party will decide among the 3 deputies Who takes over? Assuming that Abure is no longer the chairman. So there's 5 men in the executive of about 18 came together and decided to create problem for the party, decided to break away from the party, and decided to start dishing out misinformation, lies. This is the CTC, very clear about that. You cannot see the name of our candidate, Achon, both in Imo State, Kogi State, and Bayelsa State. They were not part of it, but they have gone ahead. The lawyer went ahead and said what the appeal court did not say. From beginning to the end of this, you will not see their names there. So that is why we are grieved, because we can understand when politicians are talking. But a man that calls himself a lawyer, going on air, on a national television to dish out lies, propaganda, mischief, it's something that will not encourage. And that is why we are taking this step, so that a disciplinary action must be taken against him. That is the essence of why we call this meeting. Thank you so much. When the judgment came, and we are not told, we are not put on notice, so we realized, in fact, it was from their press briefing, that we realized that there was a matter before the court. So our candidate rushed to the court and said, please, we were not aware of this thing. Put us as a party. Let us join us as interested party to this. They said no, that he filed out of time, that he can no longer be. But this appeal court made it clearer. Appeal court now said that we do not even need to bother ourselves. Why? Because we are not even part of what they did. That it is their thing, that we are not part of what they did. Do you understand? And you remember that on the 5th or thereabout, the appeal court in Benin had recognized Abure as the authentic national chairman of LabourParty. So you cannot remove him because based on declaration, ex parte order, when there is a judgment, both at the lower court and the higher court. And the party has its constitution. If you want to remove a chairman, you will have to go to the order, the constitution of the party. Do you understand? You have to go, you call a NEC for that purpose. The NEC will sit and elect among the deputies. We have 3 deputy chairmen. We elect among them. But these people were in a hurry. They were in a hurry to grab position. The moment the order came, ex parte order that lasts for 14 days maximum, and their own is lasting for eternity. Ex parte order, if it is not renewed after 14 days, it has elapsed. And that's what the law says. And their own is lasting for eternity. But they couldn't do anything because there is a court appeal that's already said that they should stop whatever they are doing. So let them see if the court has the jurisdiction. Because that's what we are saying. We are saying that that court that gave the judgment does not even have jurisdiction. Say, appeal court, please help us. There are cases with that judge himself that he did. And Supreme Court reversed him. Appeal court reversed it, and Supreme Court okayed it. The same manner. Internal matters of the party remains an internal matters of the party. So long as you have not gone astray of the rule, the laws of your party,